Hello one, hello all. Following the court proceedings yesterday, a lot is being said about what exactly transpired in court yesterday. And it's important that we give the view of the office of the SG, interim SG in this case, Mr. Sengezo Tshabangu. And in doing so, it will be important to appreciate what exactly was the court asked to do. Because in the absence of that, then we'll be susceptible to this propaganda machinery on overdrive. But what exactly was the court asked to do? Now, for the purpose of assisting you understand the actors and the players in this case is I'm looking at the Senate papers. So they are the recalled senators who in this case are the plaintiffs. So when we are talking of plaintiffs, we are talking of one Gideon Shoko and others. That will be the recalled plaintiffs. But I will presume that it's the same as well for those who were recalled from the National Assembly. So when we're talking about the plaintiffs, that's what we're talking about. And then in their papers, they've got respondent number 1. The interim SG, Mr. Sengezo Tshabangu, is respondent number 1. And then they had the president of the Senate as respondent number 2. So I would presume the papers for the National Assembly, they would have had the speaker as respondent number 2. When you hear me talk about the plaintiffs, in this case I'm talking about one Gideon Shoko and others. When I talk about respondent number 1, I'm talking about the interim SG, Mr. Sengezo Tshabangu, respondent number 2, that's the president of the Senate, right? So this was their prayer. This is what the plaintiffs prayed. So Shoko and others, this is what he prayed, or they prayed. They prayed for that one, the court grants them an order declaring the recalling of the applicants as members of parliament to be declared illegal, null, and void. And then their second prayer was an order declaring that first respondent had no right, authority, or mandate to write letters to second respondent purporting to recall applicants from parliament. Their third prayer, an order declaring that no valid letter advising second respondent that applicants had ceased to be members of CCC was written by first respondent. Then prayer number 4, an order declaring that applicants be deemed to be still members of parliament. Prayer number 5, an order interdicting respondents from interfering with the applicants' functions as members of parliament. Now, there is something which you would not have known because they would not have told you. Because before we arrive to court for oral arguments, we exchange papers, right? So they make their case, we oppose it, they put what is called their heads of arguments, we put our heads of arguments. So it was during that process that the interim SG was able to deduce concessions from the other side. What concessions? Number 1, it was the fact that as far as parliament is concerned, they were in the wrong platform. That they had no local stand whatsoever to involve parliament. And so when you see this withdrawal that a lot of you must have heard of about now, that when we got to court, the applicants altered or amended their prayer or amended their case to the effect that the president of the Senate and the Speaker of Parliament was completely removed. was removed from the case, which then would have left the interim SG and them in court, right? So now let's deal with that. From the prayers prayed here, all 5 of them, and I can start from the bottom going up so that you see, if they have removed Parliament, let's see what did they pray for from the court yesterday. So from bottom up, an order interdicting respondents from interfering with the applicant's functions as members of Parliament. So if Parliament is no longer there, and now you are basically have only the interim SG, I'm not sure how practical this order is. It's not practical at all, right? And then the second order from bottom says, an order declaring that the applicants be deemed to be still members of Parliament. This order is defective in the fact that they ceased to be members of Parliament by reason of their political party withdrawing them. So before you attack that withdrawal by the political party, you can't have this type of order. Right, third order from the bottom. An order declaring that no valid letter advising second respondent, remember the second respondent has fallen away, there's no more second respondent. So this prayer also falls away, become defective. Remember there are 5 prayers. So we've gone 3 prayers that are completely defective, that are completely cannot be implemented. 6.3 now, which is the 4th prayer. An order declaring that first respondent had no right, authority, or mandate to write letters to respondent number 2, purporting to recall applicant from Parliament. Now, we no longer have respondent number 2, remember. They've completely removed the respondent number 2, and they're now saying an order declaring that first respondent had no right or authority or mandate. But who is this challenging? Let's say for argument's sake, respondent number 2 was still there. In the absence of the party challenging the actions by the interim SG, no other individual can challenge him. You can't have an individual party member saying you are not the SG. It is the party itself that must come and say, you have no authority, you have no right, no mandate to write letters on our behalf. But the party is absent here. So this prayer number 4 also falls away. Right, the final prayer now, from bottom up, the first one. An order declaring the recalling of applicants as members of Parliament to be declared illegal, null and void. Now, it's not possible because remember, this is now established law in this country. When a recall is made, it's not Parliament that makes the recall. It's not any individual that makes the recall. It's the party that makes the recall. Now, before you can attack the validity of the recall or not, as far as Parliament is concerned, you must first of all attack the party processes. And in the absence of the attack of party processes, you have no case. So, as I close this, you need to appreciate that the interim SG said the party did not join the applicants, nor the president did not join the applicants because the party and the president are not with them. If the party and the president were with the applicants, having seen that in the SG's papers, they would have gone to the party, they would have gone to the president to seek for their sworn statement, in this case affidavits, for them to be part of this case. You can't be part of this case in the streets there making statements and letters. Those letters have been done before. We know that whatever letter you write to Parliament, it's ineffective. write an affidavit to court. It will work for you. So in a nutshell, folks, that's what transpired yesterday in court. And I can tell you that this case is going to fall down on standing. They have no local stand to challenge the SG. They have no local stand to challenge his authority. And as a result, as long as the party is with the SG, as long as the president is with the SG in not challenging the SG is well within his rights and is acting well as a chief administrator of the party to carry out the wishes of the party. I thank you. I hope in this short explanation you have an appreciation, at least from the office of the SG, how we view what transpired yesterday in court.